We're going to now go to our next speaker, fantastic, who is Gunda. So Gunda Schumann is a lawyer, sociologist, author, board member of Lesbian Action Centre, LAS, Reloaded EV. And she is going to tell us about information on the status of lesbians in international human rights law. So thank you so much, Gunda, and thank you for the work on this document as well. And over to you.
First, a couple of words to the background of non-discrimination clauses in international human rights law. It has all begun with, quote unquote, other status in the UN Universal Declaration of Human Rights, 1948. Article 2 reads, "Everyone is entitled to all the rights and freedoms set forth in this declaration without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status." Other status means that the list on prohibited grounds of discrimination is not exhaustive and other grounds may be incorporated in this category. So far, so harmless. However, this loophole was used by NGOs with consultative status at the UN. As early as in June 2006, even before the publication of the so-called non-binding Yogyakarta Principles, they demanded the inclusion of sexual orientation and gender identity as protected categories in international human rights law before the newly founded UN Human Rights Council. Has this strategy been successful? And how far are lesbians affected by these categories? Now we should go into the details. In the following, the protected categories of sexual orientation and gender identity started to make it in commentaries, comments, and guidelines of committees in charge of the UN covenants, for example, the Committee on Economic, Social, and Cultural Rights, General Comment number 20, as early as 2nd of July 2009. But that was not sufficient to trans activists. They aimed to establish a new UN body in charge of gender identity, thereby piggybacking on sexual orientation that had been mentioned in General Comments number 14 of 2000 and 15 of 2003 on health and nutrition issues of the previously mentioned committee in the context of HIV/AIDS. The focus was on gay men. On 30th of June 2016, the UN Human Rights Council, established on the 15th of March 2006, passed a resolution creating the mandate of independent expert on protection against violence and discrimination, abbreviated CEDAW, based on sexual orientation and gender identity. That was HRC Resolution 32-2. Quotation, "The mandate was created on the basis of Article 2 of the Universal Declaration of Human Rights, its equality and non-discrimination provision, ensuring that nobody is discriminated against on the basis of the listed grounds and also other status, making this an open list where gender identity and sexual orientation can be read into the article." In fact, the HIC resolution established the mandate of CEDAW has no specific legal basis in one of the United Nations treaties, nor a direct reference to a recognized protected category. The political rather than legal character of this mandate is reflected in the voting pattern of the 47 member states of the Human Rights Council. 23 in favor, 18 against, 6 abstentions. In the following, the CEDAW expert developed a narrative embedding gender identity in human rights law as if it were an inevitable and natural part of the fabric of human rights. And sexual orientation and gender identity were going to be conflated in the report of CEDAW titled The Law of Inclusion 2021. Interim conclusion: sexual orientation as protected category is historically focusing on gay men, while both categories, sexual orientation and gender identity, have been conflated by the CEDAW expert, thus merely focusing on gender identity. Now I come to the group. How does WDI UN Lobby Group come into play? As we have heard, the WDI UN Lobby Group has drafted a submission requesting the ICC to reinstall sex as a protected category for women as a sex class. According to the ICC policy, the status of lesbian women is protected from discrimination by the social construct of sexual orientation, which is lumped together with the category of gender identity. However, a critique of this categorization was not considered relevant for the purpose of the submission. Furthermore, this questionable protection did not raise any fundamental concerns. Following this logic, lesbians would not be protected by the category female gender in brackets sex within the context of society, but as a social construct together with gender identity. After my protests and further discussions, 2 paragraphs have been changed accordingly. Number 38. By conflating sex and gender, women, including lesbians, are left open to forced association with men and are thus vulnerable to violence. If you do not include sex at its own discrete category, women, including lesbians and girls, are insufficiently protected because the biological basis of their oppression is left to individual state parties to either include or not include in gender as they see fit. If, for instance, a lesbian is classified by a state party as a different gender from a heterosexual woman because that state party determines sexual orientation to be a key aspect of gender, different protections may apply to women based on their sexual orientation, and indeed, some women may not be classed as a gender of woman due to that sexual orientation. However, sexual orientation is based on sex, not on identity. Classification of lesbians by any state party as a different gender from heterosexual women would be unacceptable and would divide the sex class of women. Paragraph 52. It refers to Article 2 in the ICC policy, refers to social constructs and criteria used to define gender, and that these include constructs about sexual orientation, gender identity, and gender expression. Now our paper. The material class of physical biological sex is not determined by an individual sense of self, performance choices in terms of feminine or masculine clothing or behaviors, or sexual orientation. A lesbian woman engaged in same-sex sexual activity, or a woman who chooses not to perform femininity, for instance, is no less a member of the sex class of women than a woman who does perform femininity. Thanks.